My name's Janine Smithson and I'm from Smithson Lawyers on the Gold Coast. This presentation is going to talk about the topic of divorce. The information contained in this presentation is general information, and if you require more information relevant to your own particular matter, please do not hesitate to contact our office on 0755 620 622 or visit our website at www.smithsonlawyers.com.au. So what is a divorce? Divorce is the legal ending to a marriage. It is the piece of paper that confirms that you are no longer married. There's no requirement for parties who have separated to get divorced. However, there may be consequences in relation to the division of assets if parties do not finalise their divorce. Parties to a divorce should be aware that a divorce does not always finalise financial circumstances or matters involving children. Those issues are separate and can be dealt with as soon as parties separate. There is no need to wait until divorce proceedings are commenced or finalised. So what do you have to prove to get a divorce? There is only one legal requirement that you must prove to get a divorce, and that is that the marriage has broken down irretrievably. To show this, you need to show that you have both been separated for at least 12 months prior to making the application for divorce. You also need to show that either you or your partner are an Australian citizen, or that one of you live in Australia and consider it your permanent home, or that at least one of you normally live in Australia and have lived here for at least 12 months prior to the application for divorce. This means that even if one party lives overseas, you can still make an application for divorce. It is necessary for couples to be separated for at least 12 months prior to making an application for divorce. But can you be separated while still living together? The answer to that is yes. You can be separated and continue living under the same roof. What the court will require is evidence that you are no longer living together as a couple. Some factors that a court may consider in determining this are the sleeping arrangements of the parties, whether they are sharing meals or attending social occasions as a couple, whether they are sharing money or bank accounts, and whether their family and friends know about the separation. It's not necessary to prove all of those factors in showing that a party is separated under one roof. Sometimes couples who separate will get back together during their separation period. This will not have an effect on the 12-month separation period, provided that the time that they get back together is only on one occasion and is for less than 3 months. It is not necessary to show that it is one or the other party's fault when applying for an application for divorce. The reason for this is Australia has a no-fault policy. It's also not necessary for both parties to agree to the divorce. That means that you can make a sole application without the other party consenting to it. If the parties have been married for less than 2 years at the time of making the application for divorce, they will be required to attend counselling. The counsellor will need to sign a counselling certificate, and that certificate will need to be filed on the ComCourts portal. If there are special circumstances, such as family violence, or you're unable to locate your spouse, then the court can decide that counselling is not required. It will be necessary to set out an affidavit with all of those circumstances, and that affidavit will need to be filed on the ComCourts portal. So how do you apply for a divorce? You will need to complete an application for divorce, and this application will need to be filed at the Federal Circuit Court through the Commonwealth Courts portal. The portal can be found at www.comcourts.gov.au. If you have not previously registered on the ComCourts portal, you will need to register before you can file any documents. The fees for an application for divorce will need to be paid at the time of filing the application. To find out more about the fees for a divorce application, go to the Federal Circuit Court website at www.federalcircuitcourt.gov.au. If you hold a concession card or you're experiencing financial hardship, you can make an application for a fee concession. Further information about fee concessions can also be found on the Federal Circuit Court website. When making an application for divorce, you can either make a joint application or a sole application. A joint application is where both parties are filing the application together. A joint application must be signed by both parties before it is filed in the Federal Circuit Court through the ComCourts portal. The benefits of a joint application are that you don't need to arrange for the application to be served on the other party. You also don't need to attend court, and you can share the filing fee. In circumstances where the other party will not agree to a joint application, or you do not wish to file a joint application, you can make a sole application, which means that you will make the application on your own. You will not need the signature of the other party if you are making a sole application, but you will need to serve the application on the other party after you have filed it on the ComCourts portal. Once you have filed the divorce application on the ComCourts portal, you will then need to serve a copy on the other party. Serving just means providing a copy of the divorce application to the other party. You can do this by hand delivering a copy of the divorce application to them. You will also need to provide them with a copy of the marriage, separation and family brochure, which can be found on the Federal Circuit Court website. Once you have served the documents, you will need to complete and sign an affidavit of service. This document can be found on the Federal Circuit Court website. This document just confirms that the documents have been served on the other party. Once you have signed the affidavit of service, it will need to also be filed on the ComCourts portal. If you are unable to locate the other party, then you will need to show the court that you have taken reasonable steps to locate them. You can do that by filing an application in a case and an affidavit setting out the steps that you have taken to serve the documents. In the application in a case, you need to request that the documents be served in a different way. This may include by serving them by email or to the other party's last known address, as you are unable to locate them. Both the application in a case and the affidavit will then need to be filed on the ComCourts portal. You will not need to go to court If there are no children under 18 and all the requirements of the divorce application have been complied with and the other party is not objecting to the divorce. If there are children under 18 and it is not a joint application, you will be required to attend court on the date nominated. Provided all the requirements for a divorce are complied with and there are no objections to the divorce being granted, the court will normally grant the divorce on the day that the matter is heard in court. The divorce, however, will not become final until 1 month and 1 day after the divorce order is granted. A copy of the divorce order will be mailed out to you by the court, and you should keep that document in a safe place. Getting a divorce is not easy. If you need more help, please contact Smithson Lawyers Gold Coast and arrange an appointment for a free initial consultation.